Hello guys, this is Professor KACHALIA and welcome to the second part of the RTP discussion. In this video, we are going to discuss the descriptive questions. Descriptive questions are starting from question number 16, but as you can see on the screen, I am starting from question 17. Sir, why like that, sir? Because guys, in question number 16, there is some error. Some error is there, some clarification is expected, some clarification is required, and it is still awaited from the institute. So once I receive that, I will record the 16th question again for you. Okay. In the meanwhile, let's begin from 17 and reach up to 25 in no time. What is your question number 17? First of all, let's read the question. Question 17, sir. Yes. What is the question? The tribunal has made an offer for order for the winding up of the company known as LTR Private Limited. Consequently, meaning after considering the report of the liquidator, okay, so tribunal passed an order for winding up. Winding up order passed means liquidator appointed. Liquidator has made a report, and in his report, liquidator is stating that Mr. Tejas has committed some fraud in the formation of the company. In the formation of the company itself. Okay. So what tribunal is saying, tribunal directed Mr. Tejas, come here, be present in front of us for examination, right? Mr. Tejas is saying that, tribunal, why are you calling me? Why are you calling? I was never a promoter of the company. I was never a director of the company. I was never an officer or employee of the. I have no relation only with the company. Tribunal, I have no relation with the company. Why are you calling me? Okay. What is the question in front of us over here? Question is, examine the tenability of the stand taken by Mr. Tejas, that if tribunal is summoning him and if he still does not be present in front of the tribunal, is it okay? Alternatively, also they are asking us to examine the rights available. Okay, I will just highlight it for you. Enlighten him of what rights are available to him while at the time of examination under the provisions of Companies Act. Pretty straightforward question it is, I would say. Pretty straightforward question. I mean, I would expect this question to come in a bit of a more complicated case study. But anyways, nevertheless, straightforward is even better for us to revise, right? So here in this section, what are they talking about? In this question, they are talking about power of the tribunal to order a person to attend whenever he is summoned and examine such person. What does the provision say? They have given a reference of section 300. You can read the provision on the screen, which says that as per section 300, whenever winding up is ordered and order of winding up is made, subsequently liquidator is appointed, subsequently liquidator finds some report, something wrong in the company, and he files a report, I would say, files a report stating that the director of the company or the promoter of the company is engaged or involved in some kind of a fraud with respect to formation of the company. Okay, fraud with respect to formation of the company, or as per the language of the act, they say promotion of the company, formation of the company, business or conduct of the affairs of the company. Anywhere, if you are involved in any such kind of frauds or cheating or anything, in that case, point number one, tribunal can direct what? A summon order. You can be summoned in front of the tribunal. Yes, you can be summoned in front of the tribunal and be examined as to the promotion or formation or conduct of the business, or as to his conduct and dealings as the officer thereof. They have given his conduct in dealings and officer thereof as the third point, which is not appropriate way to write. So we are putting it as a second point, additional parties. Just a correction we did in the article. Hence, provision says as per section 300, this is the provision of the law. So Mr. Tejas, whether you are involved or you are not involved, now I don't care. You are involved in the promotion, formation or no, I don't care. Business affairs or no, I don't care. Tribunal has summoned you. You should be present in front of the tribunal, and that's it. No further arguments. Tejas is saying, but what are my rights if I have to be present in front of the tribunal? Do I have any authority? I mean, why is the tribunal calling me? What can be the reason for calling me? Tell me something at least. Yes, of course. We will enlighten you about your rights available, Mr. Tejas. You have basic two rights. Right number one, you can demand a copy of the report which is filed by the liquidator against you. Liquidator filed a copy to the tribunal saying that you committed a fraud. demand a copy of that report, but whatever is the cost for the delivery of that copy or whatever has to be paid by you. Do you agree, Mr. Tejas? Are you ready to bear that cost? We will send the copy to you. Point number one. Point number two over here specifies very clearly. What? Point number two specifies that Mr. Tejas also has the power to appoint a CA or a CS or a CMA, what we very easily call CMA, normally called CMA, they write it as a cost accountant, even a legal practitioner. That is the power. Yes, this person, CA, CS, CMA or a legal practitioner who is appointed by Mr. Tejas as a representative of Mr. Tejas, this person will attend on behalf of Mr. Tejas in front of the tribunal. But then whatever this person says, whatever this person who is a representative says, whatever he states, whatever he claims, everything will be as good as on behalf of Mr. Tejas, and Mr. Tejas will be held liable for that. So, Mr. Tejas, would you agree for the, as a matter of fact, to appoint somebody, or would you like to go on your own? Yes, Mr. Tejas, this is your time to answer. Understood? So we are enlightening in this way Mr. Tejas about his rights. Is that clear? So very simple question from your winding up chapter. Yes, the entire answer is there in front of you also. Alternatively, you have the RTP on the institute's website also. You can download it from there as well. Let's go to the next question, sir. What is the next question about? So the next question over here talks about question number 18. It says Maharaja Limited is a company, and this company has proposed to appoint Mr. Mantri. There is some Mantri over here as the managing director. They are proposing to appoint him as MD for a period of 5 years. Fair enough. MD are appointed for a span of 5 years, so that's good enough. With effect from 1st May 2022. So they are appointing him from 1st May 2022. Okay. Mr. Mantri fulfills the conditions given under Schedule 5 of the Act. Lovely. Superb. No problem. The terms of appointment are salary, he will get rupees 1 lakh per month. Okay. Commission may be decided by the commission means profit-based commission or remuneration. Commission means profit-based commission. Profit-based commission. And other perquisites also he will be receiving, plus free housing, medical treatment, leave travel, club membership, accident insurance, gratuity. Wow, lovely. What a life you are having, Mr. Mantri. I envy you, right? Here they are saying you are the secretary of the said company. You are the secretary of the said company, okay? And are required to draft a resolution. Sir, I am doing a CA course, sir. I am not a company secretary. Yes or no? That will be the doubt that you might have in your head at this moment when you read this. It's okay. As a secretary of the company, you should know how to draft this notice. Reason I will tell you. Reason is very easy. What you know? Ultimately, as a chartered accountant, auditor, you are going to check whether it is drafted properly or not. So whether it is drafted properly or not, to check that, first of all, you should know how is it supposed to be drafted. Am I right? So yes, let's understand how the drafting is done. Okay. So see, when we talk about drafting, no, there are some basic rules about drafting. Okay. These rules are given in my notes also, in my book also. Entire resolution, how to draft this resolution or any resolution of this type, you can refer to page number 57 if you have in my book. Okay, same thing is given over there. Rules for drafting. First of all, whenever we draft any resolution, you have to ensure what should be specified in every draft. Okay. First of all, subject should be there. Nature of the resolution should be there, and a name of the passing authority should be there. Okay, clear? So this is your subject is appointment is given. So appointment is given, so you should know appointment of the director is done by passing ordinary resolution in general meeting. Basic thing first of all, correct? But when you are appointing managing director, even OR in BM is required to be passed. Correct? Okay, that is point one. Then you will open the inverted commas and use the words resolved that and resolved whatever is given in the question. So let's see what they have done. Yes. A resolution passed at the meeting of the board of directors. As I said, first of all, you will have a board meeting, board resolution also. After that, it will be approved by shareholders in the general meeting. So here the first meeting is taken. Board meeting of board of directors. Most important thing is here, held at its registered office. This is important. Situated at dash, on dash day, on dash date, at dash time. If it is not given in the question, you are not supposed to write it in your own words over here. Do not write any names. Do not write any address. Do not write any time. Do not write any date. Nothing, nothing, nothing at all you will be writing over here. Absolutely no. Starting with the words resolved that with inverted commas open. Consent of all the directors present at the meeting be and hereby accorded to appoint Mr. Mantri, who is already a managing director of another limited company, and fulfills the conditions as specified in Schedule 5. So first of all, you should know we are talking about section 203, 204, 205. Yes, 2045 functions of the CS. Drafting is one of the function. 203 appointment of KMP. Appointment of KMP, there is a requirement over there. If you are already a chairman or MD, WT at one particular company and willing to get appointed somewhere else, unanimous resolution is required to be passed. So what are they saying? All directors, all directors, all directors. Understand these small things in the answers. Yes, it will make the chapter also interesting for you. It will make the subject also overall very interesting for you. Understood? Apart from that, they are saying the managing director of the company, you want to appoint him for 5 years. So here, if you understand what we are doing, right from here to here. Actually, I would not say here also, till here. We are just copying the question. That's it. You need to understand the first two lines. Resolved that the consent of all the directors of the meeting, all the directors present at the meeting, meaning you have already informed the paper checker that you know which provision is applicable over here. You are very much aware which section of the law is applicable over here. So by this much, you have already specified, you have already made it clear that you are not a puppet who is reading and writing like a parrot. Your intentions are clear. So in the first few lines, starting from here to here, you have to explain what you know, what is actually required. Then it is just copying of the question. Whatever is given in the question for passing resolution, just copy that. And then we will resolve further that as a CS of the company, be and hereby you are authorized to prepare all the legal documents and file with the registrar. File with the registrar all the necessary forms, all the necessary returns to ensure that the appointment is done in a valid manner. Language, you can change a little bit here and there. There is no issue. You don't have to muck up the language. Content should be same. After you give authority to CS, inverted comma should close. That's it. Sign of the board of directors, name of the company, job over, 5 marks in your pocket. 5 marks in your pocket. If I say it may not come for 5 marks though, but still 4 marks minimum, it should come, it will come, and 4 marks are in your pocket. Understood? That's how easy this provision is. Clear? Understood? Okay. Let's go to the 19th question in front of us now. 19th question number 19, sir. What is there? Charming Limited. Wow, what a name of the company there. Charming Limited. It's a listed company. Whoa. The moment I read the word listed company, the immediate thing that strikes to me is SEBI. Something related to SEBI will come over here. Let's see. Has constituted NRC. Okay, listed company NRC, meaning section 178 Companies Act plus SEBI also has NRC for listed companies. So both provisions are there. Let's see what they are asking. Consists of 5 members. Okay. Chairman of the committee is ID. Chairman of the committee is independent director. Is this a requirement under Companies Act that the chairman of NRC should be independent director? No, sir. SEBI? Maybe. We will check. Slowly. and 3 other independent directors are present besides the chairman of the company, who is a whole-time director, has also been adopted as the chairman of the committee. Okay, okay. Based on the given information referring to the provisions of LODR, what we have to check? First, compliance requirement in the composition of NRC. Second, quorum for the meeting of NRC. Let me tell you, those who are not very much updated with the provisions or the amendments, this question is coming in your exam. This is your latest amendment. Understood? This is your latest amendment in your chapter of SEBI LODR. Clear? Hence, it is there in the RTP also, and hence it automatically becomes super, ultra, pro, max, alpha, beta, gamma level important for you. I will show the amendment also to you, and how the composition of this committee is made, that also I will show it to you. Let me just scroll it for you. See this. If you can see this, guys, this is from my summary notes. Yes, this is from my summary notes. You can very well see the latest summary notes where the provisions we have added over here. This is the provision with respect to NRC, where applicability minimum number. Okay, page is not loading. Let me load it again. Anyway, page is not loading over there. Never mind. I'll bring you back to the RTP. Yes. So yes, in the notes, as you saw, composition of NRC entire process is given. 2/3 is the minimum number of members now required. Old provision was 50%. Now it is not 50%. It is 2/3 as per SEBI LODR, not as per the Companies Act. Understood? As per the SEBI LODR, now it is 2/3 requirement. So I will bring the answer in front of you. See this. There we are. So, as per regulation number 19 of the SEBI LODR regulations, Board of Directors shall constitute, BOD shall constitute NRC. As a part of this NRC, they are saying the compliance requirement of composition of NRC. First, committee shall comprise of at least 3 directors. All directors shall be non-executive directors. Requirement of LODR. At least 2/3, I said, at least 2/3 shall be independent directors. At least 2/3 shall be independent directors. The chairperson of the listed entity, whether is executive or non-executive, may be appointed as a member of NRC. Chairperson may be appointed as a member of NRC, but he will not become a chairperson of the committee. Chairperson can be appointed as a member, but chairperson of the company cannot become the chairperson of the committee also. No, different people will be appointed. The NRC of Charming Limited meets all these requirements. If you read the question again, you will realize it meets all the requirements, and hence it is in compliance with SEBI LODR regulations. Point number 1. Question number 2 was quorum. Sir, what is the quorum required? Quorum, either 2 members or 1/3 of the total members, whichever is higher. Same like company law, yes or no? Yes. Same like company law. Section 174, quorum. Same provision is there, 1/3 or 2, whichever is higher. Only thing extra over here is at least 1 independent director should be compulsorily present over here in this NRC meeting. Understood? So that is one extra point which is required. Otherwise, answer is same. You want to refer this answer from our notes also. You can refer it from our notes also. This answer is there in our notes. I will tell you the reference if you want. It is given on, if you are my student and having my notes, it is given on page number 204, 205 of the latest copy of the book. Yes, on the latest copy of the book, page number 204 and 5, this entire table which I showed you on the screen some time back, it is there. Yes, you can take it from there. Understood? So yes, exact concepts are there from our book. Nothing you need to go outside, do anything from outside. Just refer the notes very properly and your job is done. Clear? Let's go to the next part, sir. Question number 20. Sir, what is question number 20? Let's go through the question first. S&M Private Limited, classified as a small enterprise. Okay. Small enterprise. Corporate debtor. Oh. Corporate debtor means insolvency bankruptcy code, and small enterprise means MSAB portion. They are talking about the PPIRP concepts, pre-packaged insolvency resolution process concept over here. PPIRP. They have made an application to the adjudicating authority for initiating PPIRP. We knew that already. Requirement for filing application specified by adjudicating authority by an order admitted an application commencing PPIRP. Okay. Referring to the provisions of IBC, we have to answer 3 questions. 1, 2, 3. First, external agency of which an approval would be sought based on the base resolution plan prior to making the application for adjudicating authority. We need to explain this. First of all, can we take approval from external authority? What is base resolution plan? Do you know what is base resolution plan? Guys, these are very important concepts, okay, in this chapter. Super important concepts of PPIRP or of IBC chapter as well. If you know it, nothing better than that. But if you do not know, PPIRP video has also been uploaded by me on YouTube as a part of amendment. Latest one, you can just YouTube search Harsh Kachalia PPIRP. You will find the video. Understood? Without fail, refer to the video. Without fail, I'm saying, guys, refer to the video. It will be very, very important for your exam. You can definitely expect question from the PPIRP portion in your exam. It is amended. Hence. Second circumstance is causing invitation for submission of the resolution plan or plans. This is your ARP, alternative resolution plans. So base resolution plan, first part they asked. Alternative resolution plan is the second question they asked. And third, consequences of not approving the resolution plan by the COC. What? Company will go into liquidation only. Let's check it out. What are the answers? So guys, as you can see, 3 questions are there and 3 points are there in the answers. Before I begin with the answers, if at all you are holding my notes in your hand already, I will tell you. Refer to page number 236 for this answer. Refer to page number 241 in my book for this answer. And refer to page number 243 in this answer. Of course, I did not make the RTP, but whoever made the RTP has made sure including at least 80% of the answers from my book. So I feel very happy about it right now, right? Anyway, first of all, approval of the external agency. What does the provision say? S&M Private Limited corporate debtor shall seek approval. Shall seek approval of the financial creditors to the base resolution plan. You can definitely seek approval of the financial creditors of the external agency also to the base resolution plan. Circumstances causing invitation, first, where the committee does not approve the BRP. BRP is approved, then I don't need alternative plan. BRP is not approved. Hence, I need alternative plan. 1. 2. Where is it? Base resolution plan impairs any claims owed by the corporate debtor to the operational creditor. Where the base resolution plan which you have made, that is the basic resolution, the first plan which you made, it is impairing the claims which the corporate debtor has to pay to the operational creditors. According to operational creditors, the company has to pay them X amount. According to the base resolution plan, they will be receiving only a part of that X amount, meaning it is going to impair their claim. If it is going to impair their claim, then yes, provision will be applicable. Invitation for alternative plans will be given. Yes or no? Yes. Next, consequences for not approving the selected resolution plan. Sir, if the selected resolution plan, if it is not approved by the COC, resolution will file an application for termination of PPIR. Yes, within 30 days of the date of such application, PPIRP process, entire process will be terminated and it's down the drain. Process terminated means what? Straight away liquidation next time. Clear, understood? So that is your question number 20. 17, 18, 19, 20. 4 questions we discussed. Yes, we are trying to discuss all these questions slowly, gradually, with applicable logic over here. So I hope you are also understanding the provision. Let's go to the next one. Next one talks about regulation number 15 of FEMA, something like that. They are saying in the answers. Why did I read the answers straight away? Let me read the question first. 21. Say point number 20 or question number 21. EDC Computer Hardware Limited received advance payment for export. Advance payment. Point to be noted. Remember, LIBOR plus 100 basis points, maximum advance payment that you can receive. Yes or no? Sorry, maximum, whatever advance payment you have received, on that, if you have to make the payment of interest, how much you can pay? LIBOR rate plus maximum 100 basis points you can pay. 100 basis points means 1%. LIBOR, London Interbank Offer Rate. Okay. Then they are saying, by entering into export agreement within 14 months from the date of receipt of advance payment. First, examine whether it is permissible to receive advance payment. Second, if so, what are the conditions? What are the conditions to be complied in relation to such advance payments? Okay, let us see that. You go to the Foreign Exchange Management, Export of Goods and Services Regulations 2015. Yes, go to the Foreign Exchange Management, Export of Goods and Services Regulations, and over there, you need to go to regulation number 15. In the regulation number 15, you will find an answer to this question. What is it? Where an exporter receives advance payment, maybe with or without interest, from a buyer or any third party outside India, exporter will be under obligation. What? Shipment of the goods should be made within 1 year. Rate of interest does not exceed LIBOR plus 100 basis points. How much? LIBOR plus 100 basis points. And documents covering the shipment will be always routed through the authorized dealer through whom the payment is received. I will show you. Wait. Don't be in a hurry. See this. This is how we have explained the answer. Yes, in the class. Advance payment received through exports. Yes, sir. Exporter received advance payments, maybe with or without interest. What is your obligation? Ensure that shipment is done within 1 year and rate may be LIBOR plus 100 basis points. All the documents must be through authorized dealer. Answer of the institute, answer from my notes. Do you find a difference of any word also over here? No. Why? Because we are also following same thing what the institute has given in the material. We are also following the institute's material only in the class, which makes it not only easy to learn the concept, but also following the language of the institute will help you fetch more marks. Understood? So here it is in front of you. Everything is in front of you. This is the entire FEMA export regulations. All these are FEMA regulations. Different regulations. 17 regulations are there. Everything is there in front. Right? Again, I will say, if at all you are referring my book, page 162 is the place where this provision has been explained. Page 162. Understood? Entire provision is explained. There is a proviso also given over here. Yes, proviso. You can read it by yourself. Nothing new is there. It is exactly same from what I already showed you. Okay, fine. Say question number 2, which they have asked us. Question number 2, if you remember from the question with respect to exemption. Exporter may receive advance payment with respect to the export agreement, and he can make the shipment be delayed beyond 1 year also. If the agreement so provides, there is no payment. There is no problem over there. In the view of the provisions, ED can receive advance payment. There is no issue. Yes. And he can definitely, if he complies with the conditions, as per the agreement, 14 months is given. That is beyond 1 year. No problem. he can release the shipment beyond 1 year also, that is after 1 year also. Clear? Are you able to understand what am I talking about, or what are we discussing over here? How easy the concepts can be if you understand them with logic. Yes or no? We are left with 3 more, 22, 23 and 24. What are we waiting for? Question number 22. Let's open the question number 22. So what is the question? Can you read the question? Yes. Question says, Healthcare Foundation has submitted an application to the central government for granting prior permission. Oh. Prior permission. Oh, granting prior permission sounds more like FCRA, Foreign Contribution Regulations Act. Yes or no? Granting prior permission for the receipt of foreign contribution. Okay, so it is a one-time permission, OTR, one-time registration. The value of the foreign contribution on the date of final disposal of application is rupees 3 crores. Referring to the provisions of FCRA, we have to answer 2 questions. Namely, first one, can permission for receiving foreign contribution of rupees 3 crores in installments be granted by CG? Does CG have the power to grant this permission? Wow, what a question that is. And second, compliance requirement for obtaining next installment if answer in the first one is affirmative, meaning answer in the first one is affirmative, they are themselves telling you indirectly answer in the first one is going to be affirmative only. Understood? Lovely then, sir. We got our first answer anyway, but let's read the answer which is given to us. Let's make it easier. Permission from CG. Sir, CG they are asking, sir. Sir, what question they are asking? They are asking, sir, CG. CG has the power to grant permission, or obviously CG made the law. CG will have the power, yes or no? Provision says, Rule 9A of FCRA. If the value of foreign contribution on the date of disposal of application for obtaining over rupees 1 crore, central government may permit the receipt in such installments as it deems. Hence, CG may grant the permission for receiving rupees 3 crores. 3 crore is more than 1 crore. Common sense. Okay, sir. Thank you, sir. Next, sir. Compliance requirement for next installment. You will receive in installments. So next installment, it is further provided in the second and subsequent installment shall be released after submission of proof of utilization of at least 75% of the money received in the previous installment. So money, suppose for example, is received in 3 installments, okay, or in 2 installments. However, first installment received, yes sir. Received for X purpose, yes sir. Okay, this is the purpose for which it was received. Now I want to receive second installment. No. Wait. This purpose for which the first installment was received, has the first installment been utilized completely for the purpose? No, sir, not completely, but it is utilized. It is to an extent. Not completely utilized. What are we waiting for? Yes or no? Minimum 75% of the installment should already be utilized. Only then you can go to the second installment. Okay. So next installment you will receive only after utilizing 75% of the first. Healthcare Foundation may get the next installment if this requirement is fulfilled. Simple as that. Easy. Let's go to 23. 23. Mr. Manoj managed to transfer the proceeds of crime to his son in abroad, contracting state. Okay. His son then converted the proceeds into immovable property. Something sounds like money laundering happening over here. Okay. Transfer proceeds of crime to his son, converted into immovable property. If that property would have been situated in India, it would have been liable for confiscation. Okay. Thank you for the information. Will Mr. Manoj succeed in escaping the investigation proceedings over here and the property situated abroad not being subjected to confiscation? Yes or no? Will that property be liable for confiscation which is situated outside India? Explain, referring the provisions of the Money Laundering Act. Fair enough. Logically think, first of all, think about the answer. A person did money laundering in India. From that money laundering, he received some money which are known as proceeds of crime. This money he has sent to his son who is staying abroad. His son in abroad has purchased some property over there with that money. This Mr. What was his name? What was the name of this guy, man? Manoj. This Mr. Manoj has transferred the money, but will he be liable for investigation now over here after entire money is already transferred? Number one question. Number two question, what will happen to that property which is already transferred? Can that property which is located outside India be liable for confiscation? Because as a matter of fact, we know that if the property is located in India, it will be liable for confiscation. But this is not in India. So what will? Let's have a look. What does the provision have to offer? Section 57 of PMLA, reference is given. Special court, if satisfied, may issue letter of request to the court or authority in the contracting state. In the contracting state, that state. Abroad. Contracting state means that state abroad, that country abroad, which competent to deal with such request to examine the facts, circumstances of the case. Steps such taken by special court may specify in such letter request and forward all evidence so taken collected to the special court issuing the letter of request. So what they are saying? Over here, whatever you have, you forward it to court over there. Okay. And request them to do the inquiry on your behalf if they are competent court. Right? And they will also submit whatever they do, they find after the inquiry to your special court over here. According to section 60, they are saying where a special court has made an order of confiscation, where order of confiscation is made relating to property, such property is suspected to be in a contracting state, special court may, on an application by the director or administrator, issue a letter of request to the court in the contracting state for executing such order. Meaning what? Meaning, if at all it is found that the property is there in the contracting state, in some another state, another country, state means country over here, and an order for confiscation has been made by the special court, then with the help of director of money laundering or the administrator over here, it will be forwarded to the contracting state, that is the country in abroad, and we will make them a request. We cannot give them orders. We will make them a request to execute our order of confiscation, whereby we are requesting them to please confiscate the entire property on our behalf for the time being. So Mr. Manoj has transferred the proceeds of his crime in the contracting state. Special court may by order confiscate the property situated abroad and take steps to enforce his order by following the due procedure explained above. So Mr. Manoj will not exceed in escaping the process of investigation. Clear, understood? See, in this answer, what you need to understand, when you read the question now, as a logical man, as a logical human being, as a logical person, you already know the answer, that if at all anything like this, anything wrong is done, then naturally our government will not stay quiet. Our government will have the power to pass orders over here and request other countries also to cooperate. You know that. Okay. Only thing which you want to understand in this answer is two things. First, how to write what you already know. Second, what is the section number? 57 and 60 are the two section numbers quoted. You may know the section number. You may not know the section number. Do not write wrong section numbers in exam. Okay. But the context has to be perfectly clear, perfectly correct. If that is there, you don't need to bother or worry about anything or anybody. You will get marks for that. Okay. What is 24 then, sir? What is 24? Let's talk about 24 over here. Answer the following in the terms of Arbitration Conciliation Act. Lovely chapter, beautiful chapter, Arbitration Conciliation. First, how important are the ideas of independence and impartiality in arbitration? Independence and impartiality, how important? I will say it is the heart and soul of arbitration. But you cannot write it is the heart and soul of arbitration. Right? Okay. Is the arbitrator required to disclose anything to the parties? Question number one. Second, is membership of the same sports club one of the parties problematic? Meaning, I am the arbitrator, party A, party B under dispute. I am a member of X sports club. Party A is also a member of X sports club. Oyo. Common sports club. Matter of interest. I cannot be appointed as arbitrator. No, man. Sports club will have thousands of members. I am one of them. He is one of them. I may not even know that person. Understood? So this does not result into any problematic situation over here. That's what we feel. We will check the answer. Look. Next, what they are saying: can arbitrator resign on their own account? Of course, yes. Anybody can resign. Resign means I don't want to work. Of course, yes. Do they have to give reasons for their resignation? This is the point to be noted, sir. This is something we should think about. Could an award be challenged on the ground that arbitrator had resigned without giving a proper justification? Arbitrator passed an award, and before the implementation of the award, he resigned. Can that award be challenged? Yes or no? Interesting question, sir. What should we do for this? Refer the arbitration conciliation chapter from our notes first. This particular concepts of unbiasedness, impartiality, all these concepts are there in the book. Yes or no? Everything is there in the book. All you need to do is understand the interpretation. You can write the answer on your own. Correct? Let's discuss whatever we said while reading the question. Is it correct or not? The arbitrator are having the duty to disclose anything and everything received from one party to another party. There is a feature, there is a requirement of arbitrator, a rule that he has to follow. Avoid unilateral communication with any single party. So any information received from one party, arbitrator should disclose it to other party. One party, other party, one party, other. Disclose everything. Yes. Or the lawyers might give rise to justifiable doubts that arbitrator is listening to one party, not telling it to another party. Definitely arbitrator is being biased with one party only. We should remove the arbitrator. Yes or no? That can happen. Such an association is too remote to count as a relation. What? Membership of the same club. No, it is very remote, means very remote a possibility that it will affect the interest. No. So it is not a point that will attract biasness or partiality or independence will be affected. No problems will be there. Arbitrator can resign. We said obviously he can resign. Everybody can resign. Important is what? Without giving reasons for resignation. So the parties do not affect the validity of the arbitration. This action does not affect the validity of arbitration. I'll give you an example. I told you it is an interpretive question. Read the question properly, what they have said. They have said, arbitrator resigning without giving proper justifiable grounds. Will it act as a ground for the parties to file an appeal or challenge the order? Yes or no? Direct question, direct answer, not there in the book. But what is given in the book is, what are the grounds where challenge can be raised by the parties under arbitration? Challenging of an award can be done in what cases? And if you read the cases, arbitrator resigning without giving reasons is not a case over there. Understood? So indirectly you understand, yes, I am not a bad boy, which will mean I am a good boy. Right? Which will mean I am a good boy. And learn to interpret. Your answer is right in front of you. Clear? Understood? Lovely. Next, we talk about question number 25, which is apparently our last question in the RTP. Yes? Question number 25. B Pharma Limited is a company registered in India for 5 years. Okay. Since the last 2 years, B Pharma, they are saying, not been carrying any business or operations. Not filed financial statements also. No business operation, no financial statements, no annual accounts, nothing. No significant accounting transaction. Hey, what are you doing? You are not doing any business only. You sound like a dormant company. What do you sound like? Dormant company. Yes or no? Section 455. Let's have a look. Considering the current situation, directors of the company are contemplating to apply to the ROC to obtain the status. They want to obtain the status of a dormant company. What we have to advise them? Whether it is eligible to apply to the ROC to get the status of dormant company or no? Okay. What will be your answer if B Pharma Limited is continuing payment of fees to the registrar of companies and payment of fees for rental office accounting records for last 2 financial years? Will your answer change? I don't think so. These are standard payments. Everybody has to make. Yes or no? Doesn't mean I am not doing any business transaction. Any business transaction are we doing? No, sir. Will my answer change? Gut feeling says no, sir. Let's understand. I will tell you. If you want to know the exact answer, no? So you can refer to the page 138 of the summary book, or alternatively, I'll give you in the summary book section 455 only act part is given. You can also refer to the main book. Okay, it is available on edujahan.com. It is available on edujahan.com under the free download section. You can download it and refer it. And if it is helpful for you, don't forget to bless me. Yes or no? I will always have you in my prayers, of course, till your exams, after your exams also. But don't forget to bless me, and don't forget to like and subscribe if you are watching this on YouTube. Understood? Thank you very much. And I am starting on that note with the last section. According to section 455, you already know that. What is the meaning of inactive company or dormant company? Tell us that. Inactive company may make an application to the ROC. So there is no problem. In such manner prescribed for obtaining the status of dormant company. Of course. Inactive company may make application to the ROC for obtaining the status. So, okay. Here, inactive company means a company not carrying on any business operation, no significant accounting transaction during the last 2 financial years. Okay. No significant accounting transactions during the last 2 financial years. That is an inactive company for us. Fair enough. Inactive company. Okay. Plus, they are saying not even filed financial statements, annual returns last 2 financial years. So, my B Pharma company, which is given in the question, perfectly suits the given conditions. Yes or no? B Pharma, last 2 years, not carrying on business, no financial statements filed, no returns are filed, nothing has been done. Thus, it falls within the definition of inactive company. Yes, it satisfies the conditions of inactive company. Hence, it will be eligible to apply for the ROC. Yes, it will be eligible. Understood? Second question. Let's answer that. According to the explanation given in 455, which is given in the Act itself, you don't need to read the rules. According to the explanation, significant account transaction means what it is given. They are saying any transaction other than payments to the ROC, payments required by the law, payments required allotment of the shares, or payments of what is saying maintenance of office and its records. So B Pharma is still eligible to apply exactly what we discussed when we discussed the question, right? They were eligible, they are still eligible because the expense which you are telling us in the question is not a significant expense, and hence they will definitely be eligible. Is that clear? I hope, my dear friends, this video is helping you to revise your concepts very clearly, very perfectly, and I hope that you will clear in your exams with brilliant marks. You need anything else, please write it in the chat box of the YouTube channel or the classes chat box which you are using the app and watching this video. I'll be very happy to help you in any way to cross the line and get that tag of a chartered accountant to your. Yes, God bless you, my dear friends, and I will see you in a new video with some new topic, some new amendment, some new discussion. Until then, Harsh Kachalia signing off. God bless you all. Thank you very much.